If you're going through divorce and you see 271 sanctions, code section 271, family code section, you might be wondering, what does it even mean, sanctions? First of all, sanctions means monetary sanctions. And this code section states that if someone is frustrating the settlement or engages in frivolous litigation, almost on a level of vexatious litigant, then the court may award sanctions against the other party. There are not too many cases on this topic. And I agree that the court has a huge discretion whether to award it or not. Couple cases, most recent case is Featherstone versus Martinez from 2022, where the court simply said, no, sanctions by lower court were not supposed to be awarded against mother simply because she disagreed with the litigation process. So let's dive in what can be done in terms of how often does court award 271 sanctions and really under what circumstances specifically. Because I agree the code section is really vague and it sounds scary because I get a lot of emails from opposing counsels stating, if your client doesn't do XYZ, I'll request 271 sanctions. And when I send that email to client, I have to explain a little bit more what it means and take a little bit the heat down a little bit, because it's used to force people to do what the other side wants them to do. In 13 years, I have seen a family court judge, and I appear in court on average 2 to 3 times a week, awarded sanctions 271 only one time. And that was $1,500 for filing a declaration too late, not signing it correctly. I think it was not necessary to sanction the client, but that's what happened. Other than that, I see it almost in every pleading being cited. The court uses the standard of literally if someone is engaging in vexatious litigant, meaning they file motion after motion after motion and they lose and they file it without merit. Now, how do we determine the amount? The court has to consider what's reasonable. Sometimes the court requires the other attorney who requests sanctions to provide billing how much damage, financial, and legal fees it costed the other side to spend on particular behavior. For example, if the court order says sell the house and they don't sell and someone has to file an ex parte and ask the court to sign the document so that the home can be sold without losing the buyer, well, that ex parte might cost a few $1,000s. So that's how the court will determine. However, the court is not allowed to impose unreasonable financial burden on the person the court sanctions. So the court has to look at what is the other side's financial situation. It's tricky because for 271 sanctions, you're not required to file an income and expense declaration, meaning the court does not have usually income and expense declaration from the other side, the side that court is sanctioning, in order to determine what's reasonable. So basically, court looks at the totality of sanctionable conduct, the reasonableness of how much the lawyer who is asking for sanctions spent, and also sanctions does not have to be requested in request for order. It can be requested in responsive declaration. Why is it important? Because you don't need to file your own motion. You can ask it during the divorce process. Not in reply. Reply is due 5 court days before. Responsive declaration is due 9 court days before. And the sanctions can only be asked against the other party, not their lawyer. This is a completely different code section. It's 128.5, not 271 sanction. And the person who is asking for sanctions does not have to prove an actual injury, meaning actual cost incurred. I would translate it based on this case of appeal, marriage of Tharp from 2010. So, also, final note, a sanction can be conditional. For example, the court says, I'm not going to sign this order. I'm ordering you, the other side, to sign your listing agreement. And if you don't do it within 5 days, I'm going to sanction you with X amount of dollars. That is also absolutely possible. So overall, I would recommend not to engage in conduct that doesn't promote settlement, which then brings back my clients asking, well, we should ask for attorney's fees when a client earns money and the other side doesn't earn money and they don't agree or they don't settle timely. That is not sanctionable conduct. So what I mean by that, let's say you file for divorce, then a year filing from divorce date, you have mandatory settlement conference, and during all this time you send offers and they don't respond. That's not sanctionable. Offers can be exchanged. It's confidential. So at what point does it become sanctionable? When they start filing motions, when they go through mandatory settlement conference and refuse to be reasonable, and then in trial court it comes out that their position is completely unreasonable. Do I think the court will grant sanction? Probably not, because the court has two different positions and that's the court's job to decide. So it's really hard to get sanctioned, but I would focus on effective settlement or litigation if settlement is impossible. I hope that was helpful. If you have any questions, ask them down in the comment section below. Like, subscribe, and I will see you in my next consultation. Bye.